So when you hear there's an open shooter at the school, I want to know in your mind, what do you believe is happening?
Well, my husband had called me when I was still at work, and he said there's an active shooter at Oxford High School and I can't get a hold of Ethan. And that's when I opened my phone and I saw the "I love you" text. And then I texted him, "Are you okay?" In the process of it, I was getting my stuff and running out the door, letting my boss know that I had to go to my son's school. It was on 75 when I was trying to get to the exit that my husband called me and he asked me where I hid the bullets, and I told him, and then he said the gun is missing. So instantly, I'm like, oh my gosh, he's got the gun. I didn't actually think he was at the school shooting it. I thought maybe he walked home and got the gun and was in the field by the school. I didn't imagine my son actually going into a school and shooting. And then when we got more updates, I was like, oh my gosh, he's a school shooter, he's gonna kill himself. Because in my mind, that's what school shooters have done. They've killed themselves after. So I yelled in my talk to text, "Ethan, don't do it," because I thought he was gonna kill himself.
All right, so Matt, they're kind of like in an area that you were talking a little bit about before, but again, I want to make a distinction. And we know the jury came back guilty, so I'm not arguing the jury's verdict, but there's a big difference between, in the criminal law, as I understand it, and I had listened to the jury charge, between it happening and maybe you should have known about it, and you having a conscious disregard that it was virtually certain it was going to happen. Did she do a good enough job? I guess she didn't. In getting up there and trying to explain that to the jury? Should she not have taken a stand in your mind?
Well, I think she probably, obviously we know that strategy that goes to whether your client takes a stand or not in a criminal prosecution is probably the most important decision you have to make in terms of preparing for trial and presenting any evidence that you intend to present. But here, I think she made an effort to address these issues, I think because her and her counsel knew the gravity of the situation. If your first response to a school shooter at school is to look to see if the gun that you bought for your son is still at home, and you send him a text that says, "Don't do it," to me, you're conscious of the potential for your son to be a school shooter. And here I think, they're doing the best that they can to try to rehabilitate that issue by taking the stand and testifying about it. Obviously, as you indicated, Bob, they didn't do enough because she was found guilty on all four counts. But I think that really goes to the root of the issue here. The first thing she thought is that my son could be the shooter.
Matt, real quick, just one last question for you. Do you think that right now, or in an hour from now, or an hour and 15 minutes and 2 seconds, that the defense lawyer for the husband is going to be talking to his client and talking about possibility of going to the prosecution for a plea in this case?
I think that's always an option. If you're effectively representing your client, you have to explore that option, and you have to explore it because of just what happened with regard to this verdict. If you don't do that, I think it's and the Supreme Court has said just about as much, is that it's malpractice. You have to explore that possibility of resolving a case for and on behalf of your client.
All right, gentlemen, thank you very much for the excellent commentary. I couldn't have had two better people to break down this breaking news.